In relation to the first ground of challenge under the trade limb of Article 6, the protocol was incorporated into UK law by Section 7A of the European Union Withdrawal Act 2018. Section 7A stipulates that all enactments are to have effect subject to Section 7A. Consequently, if the protocol conflicts with the trade limb of Article 6, then that article is modified to the extent that it conflicts with the protocol. This aspect of the challenge is dismissed. In relation to the treaty limb of Article 6, it is correct that Parliament may restrict the government's power to make a treaty. However, Parliament may authorise the government to make a treaty, and it may do so by a later statute, even if there is a statutory restriction contained in earlier legislation. In this case, the government was authorised by the European Union Withdrawal Agreement Act 2020 to make the protocol. This aspect of the challenge is dismissed. In relation to the second ground of challenge, the Supreme Court has previously held that Section 1 of the Northern Ireland Act 1998 does not regulate any change in the constitutional status of Northern Ireland, other than the right to determine whether to remain part of the United Kingdom or become part of a united Ireland. This aspect of the challenge is dismissed. In relation to the third ground of challenge, based on the inability of the Secretary of State to make regulations which are not compatible with the terms of Section 42 of the Northern Ireland Act 1998, the Court holds that prior to the regulations being made by the Secretary of State in 2020, Section 7A of the European Union Withdrawal Act 2018 had already modified Section 42 of the Northern Ireland Act 1998, so that at the time the 2020 regulations were made, they were compatible with Section 42 of the Northern Ireland Act as modified. Accordingly, the Secretary of State had the power to make the regulations, and this aspect of the challenge is dismissed. As I have indicated, the appeal is dismissed.